if I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before I get started, for those who don't know me, I'm a Texas trial attorney going on my 5th year in the game. Y'all see the law license on the wall signed by the 9 justices of the Supreme Court. I was minding my business and I was drinking my water. And somebody said we got motions today. Shout out to Tia for sending me some of the motions. And thank y'all for popping into the chat. I know it's some other people live, but y'all say y'all gonna come by here for a little bit. Thank you, Lady Red. Sunshine, blue skies. The song say, please go away. My girl has found another and she's gone away. With her, with my future. Y'all don't know about that. Oh, man. Shout out to Nurse Shells for coming back in the chat. Monica B. So, what's going on with all these motions that came out? My emails start digging back to back to back. They say some good motions out today. Let's see what we got. Oh, come on now. Let's see what we got. So we can get right into it. So y'all should be able to see that. So this was filed about an hour ago. Hello, Deborah C. And this was a motion filed by the defense, Deamonte Kendrick. And we know from last time, the state wanted to shut up their defense attorneys. The state saying, you're making us look bad, lawyers. Why are y'all going to all these YouTube channels? Let's just tell it like it is. And talking about us. Hey, how's it going? 313, the best side. Somebody say Doug eats love up in this motion. I don't know. I haven't read them yet. I like reading them when I read them with y'all so I can get my original and first reaction while it's hot off the press. What's going on, Keys Mobile? Shout out to Jiggy in the building. Hey, Tia, and thank you so much for sending me these motions. I thought I was chilling today. Oh, you know, I got it. I got it. So let's go through it and see what's going on. So basically, the state filed a motion to shut up the defense attorneys, and the defense attorneys filed one back saying, oh, hell no. And this is that motion right here. Deamonte Kendrick saying, oh, no, that ain't going to work for us. This is the opposition to the state's motion to restrict extrajudicial statements. Combs now defended Deamonte Kendrick in the above style case in opposition. And we have a lot of documents today. So I'm going to kind of like skip read. I ain't going to just read every single word because a lot of it is repetitive. They just repeat it over and over. Yeah, she said, how you going to chill on response today? It's war out here in these streets. They attacking the YouTube community. So, of course, we got to respond. That boy YSL case law left him some elephants. Buddy mentioned Dumbo this time in this motion. Did he mention it too in the last one? All right, let's go. Let's see what he said. So here we go. Everyone is in favor of free speech. Besides that, DA Love. Hardly a day passes without it being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything bad, that is an outrage. Not Sir Winston Churchill. Come on here, Weinstein. I'd say Weinstein a whole move. Come on, y'all ain't saying nothing in the chat. Let's keep on going. I think if you decide to admit your crimes over a beat, oh, that sounds like Fonnie Willis, I'm going to use it. I'm not targeting anyone. That's a lie. You do not get to commit crimes in my county. Oh, it's her county now, y'all. It's her county. In my county. And then get to decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible. The Honorable Fonnie Willis, Fulton County District Attorney, August 29, 2022. Hey, India. Yeah, somebody has said that. Weinstein ate this motion. I want to see what he said. He already starting off good. Let's go. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. The state would apparently like to present trial, or what let me say there, like the present trial, to be conducted in secret, behind closed doors, in hidden chambers. And how I say, y'all, with the lights off. Oh my goodness. Not with the lights off, outside the prying eyes of the press and the public, and talk their law. They don't want me to know. The state has repeatedly went in the back room in a secret meeting, trying to hide the witness's identity, even in instances where the state has made no showing of risk to the witness, despite this court's order that such showing be demonstrated prior to blocking the broadcasting of witness testimony. So basically what he's saying is, Love don't want them on the TV screen. She don't want them on YouTube. She's saying that a lot of witnesses are being threatened. Their lives are threatened. They can't come to court and testify. But the state has made no showing. Who is being threatened, Love? Ain't nobody doing the threatening but her. He go on to say, after attacking the integrity of respective counsels, of the lawyers, not only the lawyers for the defendants, but the lawyer for the witnesses. Are they talking about Melnick and Kayla? They repeatedly called Brian Steele, the Honorable Brian Steele, a liar. And then they accused the Honorable Jonathan Melnick of working for the defendants rather than for his client, Lil Woody. And now they picking some more beef, he said. He said now they turning their attention to counsel for Deamonte Kendrick. I don't know why they keep having these typos. Deamonte Kendrick. Now they coming after me, Weinstein said. But to paraphrase President Truman, he didn't quote to Winston Churchill, and then we on President Truman. Counsel does not give the state hell. Oh, what? Counsel just tells the truth about them, and they think it's hell. Come on here, Weinstein. Yes, sir. Y'all heard what the man said. He said, I ain't even giving you hell yet. You think it's hell. He said, the hell you thought this was? He been shouting out Love and Hilton in the interviews. Right? He might as well, because he know they watching. They all up on these people YouTube channels taking their links. Come on here, Weinstein. They wilding out. All right, let's keep going. In a 1.5-page motion, the state cites to Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks. They did cherry pick because I put up the comment in our last live. And they cherry pick certain comments to the rule to support its motion to instruct the defense to refrain from making extrajudicial statements about this case moving forward. No case law cited. What a case law at, Love? Somebody said she using a lot of big words in her motion now because I guess we talked about her like a dog. They said she's using all type of big words. But she ain't citing no case law. What a law is. And no finely tuned order is proposed. As the state accurately quotes, Rule 3.6 bars lawyers from making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially affecting the trial. And right now, none of the lawyers have talked to Woody directly. That'll be inappropriate, in my opinion. If you have the defense lawyers talking to Woody in interviews, okay, that'll be crossing the line because you still need to question him perhaps under oath. And the last thing you want to be accused of is tampering with the witness before you have a chance to question him on the stand. You will effectively prejudice the proceeding if you do so. And it goes on to say that the state provides no specific quotes. They just put the whole video up. They said, Judge, go find the quotes. We're not going to provide no specific quotes. Watch the YouTube video, Judge. Come watch Talk That Law. Come watch Talk That Law, Judge. And you get the real tea over here because we're going to go in. Hey, Breezy Barbie, thank you for joining. She got the cherries for the cherry picking, Love. Somebody said Love didn't write none of these motions. Yes, she is. Laughing a big word, but no law. Somebody else said I doubt she did, but no one else in the DA wants to name on these motions. So that's why she's taking the credit. Shout out to Get 'em Joe. And thank you so much, Monica B in the building. This is kind of you. I definitely appreciate it. You didn't have to do it, but you did. So thank you so much for that. And if y'all don't mind liking the video, before y'all forget, because y'all gonna say, I'm gonna like it on my way out, and then y'all gonna forget, hit the X. Let's keep going. So there's no specific quotes. I mean, y'all quoting the lyrics. Y'all quoting the song lyrics. Take this, the mother in trial. Y'all got all that. But y'all got no specific quotes from the lawyers' interviews. Instead, the state invites the court to go on a scavenger hunt. On a scavenger hunt on Talk Their Law. Oh, man, this is insanity. Of 208 minutes. What is that? Almost 4 hours. Well, 6 times 3, 180. Maybe 3.5. They want the court to go on a scavenger hunt of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. The court should decline this invitation. I agree. Because the court had already made it clear that she's not going to go back and look at none of Glanville's old rulings. She said, I'm not going back and looking at all that. So she shouldn't be on YouTube going back and looking at 208 minutes of something that was that wasn't pointed out. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meets any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusory statement. There is no argument that any statement made by Kendrick's counsel was known to or should have been known to have a substantial likelihood of materially prejudicing this jury. No argument was made because no argument can be made. The present jury has been impaneled and hearing testimony for months on top of months on top of months before any statement was made. The jury has been instructed at the conclusion of every day of trial or trail by Chief Judge Glanville. And sometimes that, when you got a motion to write, it'll be the middle of the night. Sometimes you're going to have typos. So I was playing earlier. Sometimes you're just going to have them. But we get what he's saying. Somebody said, you know what I'm talking about. You know what I mean, talk that law. Don't play with it. Through his ad nauseum admonitions. I mean, he has said it so much, we sick and tired of it. You know, when he tell the jury at the end of trial, leave your notebooks in the basket, don't talk about the case. Y'all know what I'm talking about. To not discuss the case with others or with each other. They have been instructed daily not to consume any media about the present case, yet they still probably on YouTube. No statements made by counsel for defendants can be heard by the jury to prejudice the jury. And we got a footnote down here. The only improper prejudice to the jury has been through the repeated eye rolling. Come on. And facial expressions of ADA Love, who is sitting feet from the jurors. What? Come on here with the footnote. Wait a minute, y'all. Y'all didn't tell me was all this here now. Y'all didn't tell me was all of this. Hold on now. They didn't put it in the footnote. This is wild. 313 say, woo, come on. Cassandra said it was a disaster from the beginning. Free these young men. What's a 305? Thank you for popping in the chat. Somebody said we said he eats her up. Can you read? We said it. Matter of fact, I think somebody even said something about the footnotes. Did somebody type footnotes in the chat, or maybe I'm tripping? Oh yeah, somebody right here. Doug eats her up. Yeah. All right. Anyway, we'll keep on moving. I thought I saw the word footnote. Maybe I was. Someone made a song titled "Letter to Glenville." Oh, okay, Lady Ray said the footnotes get to the meat. Let's keep on going. All right. So where we at? Number one. Okay. The state invites this honorable court, which is trying to catch up on hundreds of orders, many of which are provisional, 19 months of trial, over 100 days of testimony, and testimony from almost 100 witnesses to wade in the water through hundreds of minutes of interviews, find statements of Kendrick's counsel that might be objectionable, determine what Kendrick's counsel knew or should have known, and summon a reason about why and how they could materially prejudice a jury that is barred from even watching it. They're not even supposed to be watching it. So how are the lawyers' interviews affecting the jury? They got their daily ammunitions. And they know they're not supposed to be consuming media about the present case. And if they are, don't tell nobody. Don't get yourselves in no trouble now. This honorable court should respectfully decline this invitation. And tell the state, I ain't gonna say that. I'm not gonna say that. I'm gonna keep it good. In addition, the state conveniently fails to quote. So you know they're gonna do that. I'm gonna have to pull up Rule 3.6 because they keep mentioning 3.6, and I believe I put it up in my last live, and it gave the lawyers a chance to speak about the case in certain situations, but the state left that out of their motions, so I don't think they did a proper motion. It said the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permits Kendrick's counsel to speak in public on his behalf. Oh, okay, he got the part of the rule right here. 5BA reads that there are certain subjects which are more likely than not to have no material prejudicial effect on the proceeding. Thus, a lawyer may usually state information contained in the public record. They talking about everything that's already on YouTube. They're not talking about nothing new. We've seen it all on YouTube. So they can talk about it if it's in the public record. Each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial. I just can't get over putting on number one. He said the eye roll and the facial expressions of ADA love. So he's basically saying the information is in the public record of the present trial, which is being streamed daily to the public. To the extent that there are any remarks not specifically in the public record, Such statements are general remarks. We're just talking in general. There's nothing formal here. We're just saying how the state is losing in our motions. We just call them out. We know they mad. They don't like when we tell them they losing. It's general remarks intended to demonstrate that Kendrick should not be on trial. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel found themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives. Can somebody say Fulton County? A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Are we in the court of public opinion? Is that what we're in right now? Thank you, 305. Some of them ain't gonna like it because they're watching from Fulton County. They say, oh yeah, we wrote this motion. Let's see what he say about this one. All right, let's keep going. Bonnie and D Love said, boy, we ain't studying you. Y'all studied somebody because y'all show using a lot of YouTube links in your motions. Okay, Justice Kennedy also correctly notes that the police, the prosecution, other government officials, and the community at large, the whole community, all the time they give press conferences, they give speeches. And, you know, when she indicted them, she did a big press conference. We know when she indicted Trump, she did a big press conference. And all of this stuff is adverse to a criminal defendant. But then they want us to be quiet. By contrast, a defendant cannot speak without fear of incriminating himself and messing up his whole defense strategy. And on top of that, most criminal defendants have insufficient means to retain a public relations team. They can't call a press conference. Apart from their lawyers for the sole purpose of countering prosecution statements. Y'all come out saying, okay, we indicted all these people. They are gangs and they're destroying our city and we're going to put a stop to it. But the lawyers can't come back and combat it and counter all the things that were said negative about their client. And Weinstein said, not today and not tomorrow. Justice Kennedy cites the important role that defense counsel plays in educating the public on pending cases. Shout out to the defense attorneys, because attorneys participate in the criminal justice system and are trained in its complexities. They hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. Not only that, to the extent the press and the public rely upon attorneys for information because attorneys are well informed. Shout out to Justice Kennedy. Thank you, Justice Kennedy. He said we well informed. And this may prove of value to the public of speech by members of the bar. If the dangers of defense attorney's speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the source of danger that can validate restrictions. Are you reading this, love? The First Amendment does not permit suppression of speech because of its power to command assent. So basically, he's saying y'all can do it, defense attorneys can do it. And that's fair. You can't come on and say, we can talk about it. We can talk about your client dragging them through the mud, but we dare y'all say something about them. Somebody said, finding you up in the church giving speeches in the pulpit. Which is wild. I mean, I don't know. Maybe some churches do it nowadays, where they allow non-clergy to sit up in the pulpit in the pastor's chair. I just never seen that downhill. Maybe y'all do it different in Georgia. Brooklyn, NYC, thanks for popping back in and for joining last night. She had the church's support. Yeah, that was just strange, though. They were backing her heavy. And Weinstein go on to say, this is the exact situation that Kendrick and his counsel, Weinstein, find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. But they say Fonnie Williams don't like that. In Fulton County, this makes Kendrick a target of the state. And if he a target of the state, Deamonte Kendrick is allowed to take reasonable steps to protect his reputation. And those steps may be taken by his lawyer rather than spending extra money on a public relations firm. Y'all see what it say. Having smeared Kendrick and his reputation, the states want to silence him. How do they want to silence him? Well, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him. And now by holding press conferences denouncing him in his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. Thank you, Lady Red. Yeah, if y'all don't mind hitting the like button to circulate the vid. All right, let's keep going. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Come on now. Wherefore, Kendrick prays that the court deny the state's motion. Respectfully submitted, Douglas S. Weinstein. Thank you so much, Keys Mobile. Bam Facts. What's going on? So this is the motion, the response to Lady Love, so what they call a lawyer love. I bet you she was something else back in her day. She reminded me of an old teacher that used to wear a French roll in her head. Y'all know what the French rolls are? Y'all know what the French rolls are? Somebody know what I'm talking about. Let me see. So we have, this is just one motion that we went over. We have so many other ones. I'm gonna open up. What's the next one? Somebody say facts. What's the next motion, y'all? That's on fire. 313. The best side say French rolls coming back. Come on. She said, Ms. Yo, I'm my first grade teacher. She said they bringing them back. Let's go. All right, I'm going through. I'm looking for the next motion. I think the other ones are from the state. Did we have any other motions from the defense or all of the other ones from the state? If not, I'll go through the state's motions. Let me see which one we got from the state. We got one called Adoptive Omissions. So let's kind of go through. This is the state respond, but it's blah, 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 la, la, la. And the defense attorneys, I mean, I think they have until 5 o'clock, so we're probably going to get more motion as we talk about these. Wait, matter of fact, did I? Well, I'll go through this first, but I don't know if I went through the other ones that came out like a day or two ago. I was just going to save them, but we can go through them later on. So this is the state's motion in response. So this is something old, ain't it? Okay, so she didn't went back. So it looks like DA Love is responding to motions from some old stuff. I guess they're just trying to get them all in, but we'll go through it. An adoptive omission is pretty much if somebody says something in front of you and you don't deny it, then it could possibly come in against you. So if somebody ever joking around you and they telling people, hey, we were all robbing a bank, you better make sure you say, hell no, we was not robbing a bank. You might have been. This show wasn't me. Shout out to who was that seen that song? Show wasn't me. Well, yeah. So here we go. Let's see what they say. Oh, it sounds like this ain't gonna be no good stuff. This is just some legal stuff. Despite binding Georgia and persuasive federal precedent authorizing their admission on July 10, 2024, defendant Williams, so it can make it a little bigger, moved this court to vacate, to correct prior rulings on the introduction of adoptive admissions. So it seems like the judge Glanville let some stuff come in and the defense wanted out. And And what they're saying now is they want the new judge to throw it back out. And then DA Love, she goes on to say, Defendant Williams does not request specific relief on this matter. So I'm going to just kind of go through skip the legalese. Nonetheless, the trial court has correctly ruled on the adoptive admission. So basically what Love is saying, Glanville got it right. Glanville let some stuff come in. The defense lawyers wanted out. So it's a lot of legal mumbo jumbo in here. You know, binding, persuasive, statutory, case law, all that stuff. That's just legal stuff. Okay, the argument and citation of authority, sending Georgia's former ban on their introduction to oblivion. The Supreme Court of Georgia, in accord with federal precedent, approved the introduction of adoptive admission in criminal cases, and they did it in State v. Orr. In the state's briefing argument in this court's order on the introduction of gang lyric evidence, the concept and application of adoptive admission were delineated in considerable detail. Let's go to footnote number 3. Chief Judge Glanville ordered the admission of evidence and lyrics. So the judge let some lyrics come in, and they want it out. But Fonnie Willis already said she's going to use any lyrics that she can get her hands on. She said you're not going to come to her county and rap about confessions and put a beat on it, and she won't be able to use it. She said, I'm going to use it. Okay, let's keep going. So Rule 801 authorizes the previous court's Glanville's ruling on the introduction of adoptive admissions and governs a trial court's consideration of the same. It states the Rule 801D2B that admission shall not be excluded by the hearsay rule. An admission is a statement offered against a party, which is a statement of which the party has manifested an adoption or belief in its truth. Defendant Williams, Young Thug, is partially correct in asserting that mere silence by a party opponent in the presence of another statement standing alone does not automatically equate to an adoptive admission. However, a defendant's silence may in certain circumstances communicate that he has adopted another person's statement as true, which makes the statement admissible under Rule 801. So it may not be automatically, but if you don't denounce it and say, hey, I didn't do that, I didn't rob that bank with you, then it can come in as evidence. You remain silent, so you co-sign the statement. Let's keep on going. In evaluating whether evidence qualifies as Young Thug's or any of the other co-defendants' adoptive admission under the rule, the trial court must find that 2 criteria are met. The statement was such that under the circumstances, an innocent defendant would normally be inducted to respond. So basically, if you were innocent and you didn't rob that bank, an innocent person gonna say that. I didn't rob that bank with you. Don't be playing like that. Don't put my name in it. And number 2, there are sufficient foundational facts from which the jury could infer that the defendant heard, understood, and acquiesced in the statement. So not only did they say, you know, we robbed a bank together. Oh yeah, talk aloud when we robbed a bank together. Not only that, but I heard him say it. I understood what he meant when he said it, and I co-signed. I agree. Silence gives consent. Y'all heard that before? And it goes on to say, after this initial determination is made by the trial court, the jury is then responsible for making the ultimate determination of whether the defendant adopted the statement as true. So what Love is saying, let the jury decide. Let's just put it in front of the jury. I don't know. He didn't say he didn't do it. Let's just put it in front of the jury and see what happens. And the defense attorneys are saying, no, that's not right. But that Love, she would do anything she can to try to win this case, even while it's barely hanging on by a thread. She goes on to cite a clear example in Wilkins. It must have been another case, an older case, where the court found it was reasonable that a statement referring to a bloody shirt in the trunk of the car that the appellant drove up in and was standing next to the shirt as to the shirt we used to wipe blood and fingerprints off a gun is the kind of statement that would normally prompt the innocent person to clarify that that I guess that should be they was not part of the we. So basically, if somebody, like I said, if somebody come up and say, yeah, we used this shirt and we wiped, it was a bloody shirt in the trunk of the car and we used it to wipe blood and fingerprints, they saying an innocent person would clarify that what you mean by we? What's that song say? I was in a car when we slid. Wait, who is we? It was we, because when you start saying we and you don't clarify that I'm not part of that, then obviously they could try to introduce that against you. So y'all learning something. Yeah, Mikey B, she just throwing everything. Yeah, they have a right to remain silent, but that pertains to a custodial interrogation by the police. Like when you're being questioned while you're in custody, you know you have the right to remain silent. And a lot of people think that the police have to reach your rights anytime they question you, but it's actually anytime it's a custodial interrogation when you're in custody. And custody can be defined by a lot of different things. Custody can mean you're in handcuffs, you're in the back of a police car, you're in a room with the door closed, where you're not free to leave. A reasonable person don't think they're free to leave. So a lot of things can make you in custody for Miranda purposes. Why does it say quotation in the original? Why don't she just put them in? Yeah, she's something else. The foregoing said a direct confrontation with the accusatory statement is not always coupled with the lack of denial required for the application of Rule 801 D2B. And she goes on to cite some case law. See, for example, the cases provided below. United States v. Hankin, 5th Circuit, 2022, holding trial court did not abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an adoptive admission. Now, that's wild. So let's say it's 20 people in a rap video and only one of them rapping and the other ones are silent. They are saying that it's not an abuse of discretion. It's allowed to be admitted, even if the other people are silently agreeing or remaining silent. By remaining silent, they agree. So if one of the people are rapping, yeah, I shot up this bank and I jacked this man, and the other people in the video, maybe they silent, maybe they dance to the music, bobbing their heads. The court, the 5th Circuit, according to her citation, said that it wasn't a mistake. And I don't even know why she quoting the 5th Circuit. I think the 5th Circuit that's over here in Texas. The Fifth Circuit hasn't been a part of Georgia since the 80s. Hold on, let me see. Let's see. So we got the Fifth Circuit here. Let's see what states. So it's Texas, Louisiana, and what is that, Alabama? Let's see, I know I'm getting off on a little side note here. I was just curious why she quoted the Fifth Circuit. Okay. So when the Fifth Circuit was created, it covered Florida, Georgia, Alabama, Mississippi, Louisiana, and Texas. But then in 1982 or 1981, it was split. So Alabama, Georgia, and Florida are now in the new 11th Circuit. So, I mean, more than likely, the 11th Circuit is the best cases she should be quoting, not cases from courts in the Texas region. So, in any event, let's keep it moving. She said a case in the Fifth Circuit may have been overturned recently. Right? Yeah, who knows? A lot of times when they quote stuff, you got to go back and check because it could have been overturned and it may not even be good law anymore. Now, I know she probably quoted as persuasive authority, but the Fifth Circuit doesn't control the cases in their jurisdiction since the 80s, even though they're all federal courts. But her jurisdiction right now is the 11th Circuit. So here we go. Neal v. State is another case that she quoted. This is actually a Georgia case. Hello, Georgia. Holding no abuse of discretion by the trial court in finding defendants' pre-arrest silence was an adoptive omission when defendants stood silent after being verbally accused of having sexual intercourse with a minor. Now that's interesting right there. I wonder if that's going to hold up because your pre-arrest, silence, now you're trampling on some rights because you have a right to remain silent. So if someone accuses you of something and you don't say anything, I don't know if that's going to be adoptive omission. So more than likely, this one's probably going to be appealed if it's not been appealed already. Okay, here we go. United States v. Carter. In the 11th, okay, she heard me. Now we back in the 11th Circuit. Holding statements were properly admitted as adoptive omission when defendant remained silent in the presence of co-defendants. Discussion implicating them all in illegal smuggling activity. This is a wild law. I mean, do I gotta say I didn't do it every time somebody say something wild and crazy? Or should I just remain silent? All right, so the conclusion. The trial court's prior evidentiary rulings on adoptive admissions have been in accord with Rule 801D2B and case law of the same. Adoptive admissions may be admitted in Georgia criminal trials. Williams' motion should be denied. And then she got her certificate of service. Yeah. So what y'all think about that? Before we move on to the next one, what y'all think about that? Do y'all think it's fair for states to be able to use adoptive admissions? And y'all let me know if we get another good motion. Cause this here, it's a lot of legalese. Some time and of course as usual. Yeah. So on Tuesday, unless something's changed, that's the day that the judge should be hearing all of these motions. Oh, thank you, Mikey B, for stopping in. Definitely appreciate it. See you on the next go around. Yeah. Let me check and make sure. Let me see where we're at. You think so? And some people have been asking, like, what order will she take the motions in? And I mean, it kind of depends. Right. But see, that'll be the issue. It'd be a lot of wasted time, right? If she go through all of the motions and then grant a mistrial, that'd be a whole lot of wasted time. I think she should, if that's her intention, she should start with that. But if we start hearing her going through other motions like for bond and all this other stuff, then we can probably safely assume that she won't grant a mistrial. So that'd be like a law for her to make 20 rulings and say, oh yeah, by the way, mistrial, everybody go home. Well, yeah, and if she do that, then yeah, there'll definitely be no need to hear any other motion. You won't need to hear a bond motion because the case will be over with. They get to go home. There'll be no legal reason or authority for the sheriff's office to still hold them in custody if the case is disposed of by the judge. But I don't think that she could really just continue. I know she came out hot, a couple of weeks ago. Yeah, these are my rules. We're going to do this. We're going to do that. But when you really sit down and look at it, she probably like, this is going to be a lie. I can't do this. She said, does she have to hear motions first in order to respond? Well, a majority of the time, I believe that's why she set the time, the day for July 30th, because she said that she wanted to use that whole week to go over the motions. So she wanted to use that whole week and then bring the jury back the following week. But if they go over and run out of time for next week, then the jury will come back the week of the 12th. See, in my mind, it seemed like she's planning it so far ahead to have a mistrial on her mind. One lawyer had a great motion about the switching of the judge. Yes, we went over that too. And he basically told her, you can't do that, woman. You already said that you're not going to go back and rule on Glanville's old motions. You're not going to even consider it. She already took it out of her mind that she wasn't going to work backwards. So he's pretty much saying, how can you be fair? If you already said that you're not going to go back and consider anything, so he kind of like used some words against her. All right, so I guess we can, Tuesday's going to be interesting, yeah. So y'all want to go through the state's, the next motion? Sheesh. They're going to wear us out, ain't they? So this is the state's response to defendant's motion in opposition for correct ruling on vague questions. So apparently way back in June 10th, Young Thug's lawyer, Brian Steele, filed a motion to basically, he want to ask questions on cross-examination. What's been going on is the state will ask 1,000 questions to a witness. But then when it's the defense turn, when Brian Steele's turn to get up there and ask questions, then all of a sudden the state has a problem. Oh, that question's too vague. You're wasting time. You're extending the trial. You're assuming facts not in evidence. So all of this stuff that is just employed by the state to get the upper hand. And for those that are just popping in, y'all don't mind hitting that like button on your way in. That would definitely be appreciated. But we're going to go through this motion from the state of Georgia. So on June 10, 2024, Williams moved this court. And by this court, it's just the Superior Court. Obviously, it wasn't Judge Whitaker. It was Judge Glanville to vacate, to correct proper rulings on the state's objections. Did I read this one already? Or no? Or are they all the same? Am I tripping? And I don't think I read this one. To correct proper rulings on state's objections, precluding cross-examination with vague questions. And we got footnote number 1, July 10, Defendant Williams filed an amended motion. Defendant Williams' motion addresses multiple separate evidentiary rulings. This motion addresses paragraph 10 regarding state's objection to vague questions. Somebody said no, she just repeated everything. Okay, I knew it looked familiar. It looked like, golly, she used the same language as her previous motion. That's why I always tell attorneys it's good to switch it up, because if a judge reads 100 of these and they all start sounding alike, she might skip over it thinking she already read it. So it's always good to use different words when you can. So Williams does not include a request for specific relief or provide authority to substantiate his request. Instead, Young Thug cryptically asserts, he sneakily asserts that somehow his right to effective cross-examination has been curtailed. The trial court correctly sustained state's objections to Williams' vague questions that has not impeded defendant Williams' cross-examination. Williams' motion should be denied. So basically, they're saying that Brian still said his his questions have been curtailed. He hasn't been able to ask questions he wanted to ask because anytime he asks questions, the state objects, and he is the judge agrees with the state. And if that happens, then Brian Stitt is basically saying, there's no way I can question a witness if you're curtailing everything I do. If the judge is stopping me from asking questions. And Love, this is Love's motion. She's saying, no, the judge is right. You can't ask no vague questions. Love, what's vague? Because y'all been asking vague questions the whole trial. But D.A. Love said the trial court, Judge Glanville, was right when he sustained the state's objections to Williams' vague questions and has not impeded defendant Williams' right to cross-examination. She said at the outset, Williams never provides authority. She said he didn't provide any case law. Isn't that the same thing she was accused of? He never provides any case law of why he cannot cross-examine witnesses. Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed, even grounds that are constitutionally protected. However, may be subject to judicial controls. Control of Judge Glanville. Controlled by her man, D.A. Love. Somebody say y'all was going together. Tell them folks y'all go together. The right to inquire into partiality and bias, however, is not without limits. Let's go to footnote number 2. Oh, okay, there ain't nothing down there. Footnote number 2. The Fifth Circuit, she back in Texas, y'all, has made, oh, what happened? We lost it. She didn't went back to Texas. She didn't came back to the Fifth Circuit. Where we go? Oh, here we go. The Fifth Circuit has made it clear. Oh, let me see. The Fifth Circuit has made it clear that ambiguous questions are not constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. And then she go on a list, rule 611. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective for determining the truth. Okay, Love, effective for determining the truth. You don't want the truth, you want a conviction. Number 2, avoid wasting time. Who has wasted more time in this trial than D.A. Love and Judge Glanville? I mean, let's be for real. How you gonna quote a rule and y'all breaking all the rules? And number 3, protect witnesses from harassment or undue embarrassment. Wait a minute. Who harassing witnesses in the back room? Who was harassing Woody? Who was trying to embarrass that man? Putting all his business out about his daughter, his birthday, daughter's birthday coming up. He needs to be out teaching his nephew instead of in jail. His dog having puppies. Like, why would you put all that in the court record? The rule permits courts to preclude questions that obscure the truth because they are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. This all, she talking about herself. Somebody tell her she talking about herself. And then she back in the Fifth Circuit, United States v. Fields Fifth Circuit, 2014. Williams' motion attempts to constitutionalize Williams' motion attempts to constitutionalize and I guess she meant and areas of cross-examination that is not so protected, even assuming arguendo that vague and ambiguous questions were of the same stripe as an area like bias. And then she go on to say Williams' Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. Well, the issue is who determines what vague questions are. And when you got Judge Glanville and he's heavily pro-prosecution, I mean, it's safe to say that Glanville, if he get his way, he gonna consider everything vague. So the lawyers are saying we can't ask nothing. What can we ask? It's easier to find out what can we ask than what we can ask, because obviously we can't ask nothing. Let's keep on going. This court, not technically, when this court, Judge Glanville has correctly sustained state's objections. Who believe that? Who believe Glanville correctly sustained the state's objections to Young Thug's vague questions because such questions are an impediment to the ascertainment of truth, of the truth? Come on now. She says she want to prevent admissible evidence. And I'm kind of just skipping through reading some of this stuff because a lot of it is legalese. She want to limit asking questions in front of the jury. Defendant Williams, Young Thug, Brian Steele argues that the court's sustainment of objections for vague questions have curtailed defendant Williams' Sixth Amendment constitutional rights, but cites no legal authority for that proposition. Well, you would think if somebody is saying somebody else is not citing legal authority, you'll make sure that, you know, in their own motion, they'll have legal authority. But as we've seen, she's saying that other people don't have legal authority, but she don't have none herself. She's throwing a rock and hiding her hand. Case law explains that the Sixth Amendment provides two types of protection for a criminal defendant. What are the two types? Let's see. The right physically to face those who testify against him, and the right to conduct cross-examination. Brian still got a right to ask questions, love. Y'all ask 1,000 questions, and this man can't ask 10 before y'all object. State v. Burns, the Georgia case. But she has an exception. However, the confrontation clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent that the defendant might wish. She said you can have your cross-examination, but you can't have it whatever way you like it. You can't have whatever you like. Shout out T.I. She goes on to say, this is D.A. Love talking. Furthermore, trial judges, especially her man Glanville, retain wide latitude to impose reasonable limits on cross-examination. She said her man can limit you, Brian Steele. That's what she said. Am I reading it wrong? She said that her man can impose reasonable limits on cross-examination based on concerns about, among other things, confusion of the issues or interrogation that is repetitive. Who's being repetitive? Y'all brought the same witnesses over and over again. Y'all had witnesses, multiple witnesses testify to the same thing. And they say allegedly that Glenville is your man. That's allegedly. I don't know if it's true. If I'm not correct, come on the show and let me know that Glenville is not your man. Your man, your man, your man. And she go on to put this is a bold-faced lie right here. All defendants, this DA love talking, all defendants have been afforded and will continue to be afforded the opportunity to confront and cross-examine witnesses the state calls in this trial. The state will not object to cross-examination that is legally sanctioned. Yes, you will. You've been doing it the whole time. Williams' right to cross-examination is not a bridge where the examination is limited by the trial court to relevant matters by proper questioning. Who determines proper questioning? If it's Glanville and you're having a secret meeting in the back room with him, then we cannot trust his judgment. Keys Mobile say everything she say defense does, they're doing. But they can go a whole month questioning it with thank you. Hey, thank you for joining. Thank you for making it. What's going on, Tall Glass? Thank you for popping in the chat. Let's keep going. She say, this is DA Love talking for the ones popping in. And if y'all don't mind hitting the like button, they questions are improper. Take a note of yourself, DA Love. Defendant Williams' assertion that this court has incorrectly sustained objections to vague questions is incorrect. Now she back in her own court. She said the 11th Circuit had held that a question or phrase is ambiguous as a matter of law when it is not a phrase with a meaning about which men of ordinary intelligence, not men of ordinary intelligence, could agree, nor one which could be used with mutual understanding by a questioner and answerer unless it were defined at the time it was sought and offered as testimony. She say vague questions are not allowed. It impedes the truth. That's what she's saying. And it prohibits mutual understanding. She said, what I need from you is understanding to the meaning behind any answer by a witness. And then she had the nerve to write, she said repetitively, who been repeating questions over and over again? Proposed vague questions by Williams. Who's been repeating these same questions? She bringing all these witnesses. We've seen witnesses on the stand for days at a time, not where both sides are questioning just one side. That's been either Hilton or Love. And now she's saying that the defense is being repetitive and causing confusion. Come on now, let's be for real. The jury already confused. Can we tell the truth? The jury been home for what? How long now? Over a month. I'm sure a few questions won't confuse them. But she say, whereas unambiguous, proper questions, she said, if you ask proper questions, you will provide the jury with concise clarity of the facts, and that will better equip them to ascertain the truth. Oh, yeah. Come on, Love. You ain't slick. She go on to quote federal law. She said, federal courts have repeatedly upheld objections to vague questions of the type of questions commonly asked by defendant Williams Young Thug Brian Steele. She say in this case, the United States Court of Claims held that plaintiff properly objected to questions which were vague and ambiguous. I mean, I don't know what the United States Court of Claims. I have to. United States Court of Claims. Let me see what that is. Court of Claims. Oh, she must be in the U.S. Court of Federal Claims. That's probably why it's an extra space in there. The federal claim, they got deleted out. So she basically is saying that the federal courts give the trial courts wide latitude and discretion when it comes to keeping questions out. So it's a lot of legalese. She quoted the case. It's paramount. It's important. It's the right thing to do. She's saying for courts to sustain objections, basically to keep out vague questions, because the trial court bears responsibility of making the interrogation effective for the ascertainment of the truth. Now she quoted the 10th Circuit. In Gray, the 10th Circuit agreed with the trial court that the vague question asked by the lawyers was not helpful to the jury, and approved of the trial court sua sponte interruption of the question. That's basically where there was no objection. The court objected, which is wild. Referee, if I don't call a timeout, if I don't object, I don't need you jumping in and helping the other side. You know, if I need you, I'll throw my red flag and ask for a review on the play. And the court goes on to pretty much sustain the objection from the state. So when the state objects to vague questions by Brian Steele, Judge Glanville sustained them. I mean, that's, you know. For example, okay, she got an example here. Defendant Williams, aka his buying through his attorney Brian Steele, Young Thug, asked Atlanta Police Department Detective Belknap, do you know there are videos of countless performers or athletes where they are promoting their trade? The state objected to this question because it was vague. The question was ambiguous because it is unclear what videos, which performers, and what trade the question referenced. The court properly sustained this objection on the grounds under its inherent authority. So she say. I mean, the question seems pretty clear to me. Do you know there are videos of countless performers or athletes where they are promoting their trade? I mean, that's a simple question. I mean, it narrows it down. Countless performers or athletes promoting their trade. That's a simple yes. We know there are a lot of athletes and performers promoting all the time on social media, you know, what they do for a living and pushing their next song, mixtape, album, their next boxing event. So yeah, I mean, it's not uncommon. So conclusion. She said Young Thug, she pretty much saying his argument is invalid and unsustainable. There's no constitutional or statutory right to ask irrelevant questions. She said the prior court ruling, Judge Glanville, he got it right. So Young Thug's motion should be denied. Signed, Adrian L. Love. And obviously she submitted that today, July 26, 2024. I don't know why she submitted it so late. I mean, because she clearly said in the beginning that she's responded to something on June 10th. So it's a month and a half ago. Thank you, Chicky. That she at work on her lunch break, but she still popped in the chat. Let's see. I think we had another. Man, this is insane. And a lot of times, if you're cross-examining a witness, you really want to lead because you are allowed to lead when you're cross-examining a witness. You don't want to give them too much wiggle room. You want to lock them down. It's really the lawyer testifying through the witness. So I'm going to ask you a question to where I'm testifying through the witness. Isn't it true you were at the bridge on Friday at 5 o'clock? And while you were there, it's fair to say that you stabbed such and such at 5 o'clock. And it's also true, once you stab that person, you threw the evidence in the river. So you want to just really lock them in. You don't want to, ask them open-ended questions. Like, where were you at 5 o'clock? Then they can go on a whole spiel. Nah, we're going to lock you down. And that's how you really do effective cross-examination. Somebody said she just regurgitating previous motions. Yeah. Somebody said we about sick of her. Somebody said only word she typed while shaking her head was denied. Yeah. Let me see what other motion. I believe we went through 3 so far. I think the last one that we haven't covered was assuming facts not in evidence. So this is one of the last ones that so far. I think the deadline is 5 o'clock, and it might be 2:47 right now in Georgia. Okay, it's a total of 4. Okay, we did 3. All right. And for those popping in, if y'all don't mind hitting that like button. Thank you, Keys Mobile. So this is a motion by, I'm assuming, Love, because all the motions have been by her so far. Matter of fact, I haven't seen Hilton's name on any motion. Right, Tracy, that's interesting. Why hasn't she replied to the bond motions? That's what we really need her to reply to. The bond motion. We need to see. I mean, because she running out of excuses. First, she said that keep them in jail. People are being threatened. You can't let them out. Witnesses are intimidated. And you had all these witnesses come in. I think they say almost 100. And not one said that they were threatened or intimidated by any of the defendants or by anybody working on behalf of the defendants. Well, hard to say. What's she gonna say? I said she ain't got nothing to say. Because she in too deep. Too far in to turn around. All right, let's go through it. And I'm gonna kind of like skim read it like I've been doing the other ones, just to, because a lot of this stuff is repetitive, it's legalese, a legal mumbo jumbo. We're just gonna save some time. The state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. So this kind of look like a similar motion to the one we just read. The defense wants to ask certain questions. They want certain stuff to come in, and the state is objecting. And Glanville was on the state side. So the defense filed a motion with the new judge so they can fix Glanville's ruling. And this is a motion by DA Love. She's basically saying you don't need to fix Glanville's ruling because Glanville already got it right the first time. So let's go through it. June 10th, another motion from June 10th. And she just now responding today. Defendant Williams, Young Thug, Brian Steele moved this court to vacate, to fix, to correct proper rulings on state's objections, precluding cross-examinations questions, which assume facts not in evidence. And then we have a footnote here. Let's go to the footnote. July 10, 2024, Defendant Williams filed an amended motion. Defendant Williams' motion addresses multiple evidentiary rulings. This motion addresses paragraph 10. All right. Defendant Williams does not include a request for specific relief or provide authority to substantiate his request. Here she go again, saying somebody didn't provide authority. Instead, he on the same BS that I'm on. Love say he not provide authority, and I'm not providing authority. Yeah, this is love. This is love because this is how she talked. He's saying that the state somehow, his right to effective cross-examination has been curtailed. See, this is similar. All this is similar than we already read. And the trial court agreed with Love. And then she goes on to cite some of the authority at the outset. She said he didn't provide authority of why he should be allowed to ask questions that assume facts not into evidence. So basically what she's saying is, like, I get you can't ask like wall questions. I mean, because if you ask a random question, isn't it true that DA Love rolled her eyes yesterday? Or isn't it true that Ms. Hilton wore her favorite skirt yesterday? I mean, that's irrelevant to the proceeding. So that's something that I do think that is a proper objection. But if it's something that's remotely close to the trial, I think it should be allowed. And asking about lyrics, isn't it true other rappers, entertainers promote their business? That relates to why Young Thug is rapping about certain lyrics, because other entertainers are rapping about certain lyrics. That don't mean that they are actually living the life that they're singing about in their songs. So let's kind of just skim through it. So she quoted the Fifth Circuit again, made it clear that questions which assume facts not in evidence are not constitutionally protected. And I think we kind of went over this the last one. I mean, it's literally like word for word. Williams' motion attempts to constitutionalize areas of cross-examination that's off limits. Man, we kind of went through all of this. Oh, you got a typo here. I think you missed the S. think she meant to make it like Williams like this. But yeah. But I get it. It's a lot. It ain't gonna be perfect. So a lot of the stuff we kind of already went through. I'm gonna get to the meat. If she got anything new in here, courts are mandated to exercise reasonable control over the mode and order of interrogating witnesses. Yeah, we went over that. Defendant Williams asserts that the court sustainment of objections for questions that assume facts not in evidence curtails his Sixth Amendment constitutional right, but cites no legal authority for that proposition. Footnote number 7. Okay, nothing down there. Case law explains that the Sixth Amendment provides two types of protection. Okay, we went through that. Yeah, she really copied and pasted. Like, for real, somebody said that. I mean, this is like verbatim. What's going on, Rob? For real. He said, where's Miss Bumpers? I don't know if she went live today. Yeah, but somebody has said that it's pretty much verbatim. Let's keep going. Yeah, she said the same law all defendants have been afforded will continue to be afforded the opportunity to confront and cross-examine witnesses. She's saying that she won't object. She's gonna object every chance she get. She's saying permitting question that assumes facts not in evidence can confuse the jury. They're gonna be confused, y'all. They're not gonna know. So all she's trying to do is protect the jury from confusion. She said she using AI. AI gonna jump on here and say, no, the hell she ain't. Tracy said they being confused. Minister Fears, thank you for joining. She had a lot of things going on. Like she read the template and filled in the different motion complaints info. Yeah. Rob said that's lazy. Let's keep going. She's trying to stop the jury from being confused because they will be considering information that's never properly admitted as evidence in trial. So we get that. She goes on to quote the 11th Circuit. She said defendant Williams' young thug improper questions, which assumes facts not in evidence, could confuse the jury during the deliberation, similar to the trial judge and Almanzar. And Satterfield v. State, the appellant enumerated as error at trial counsel's failure to object to the prosecutor's questions of a witness, which improperly assumed that these defendants had created the mess, a fact that the witness did not know, which was not directly in evidence. Ultimately, the court held the trial court counsel's failure to object to these improper questions could be qualified as a reasonable strategic decision and not find prejudicial error. Nonetheless, the fact that the Supreme Court diligently undertook analyzing appellant's objection to improper questions that assume facts not in evidence underscores the validity of such an objection. Now, she just said a whole bunch of nothing. That's just too much. All right, let's get this. Oh, here we go. We got an example. Williams seeks to ask questions that implies matters at best Williams cannot substantiate. How you know that, though? That's why you ask questions, because you're trying to substantiate it. But here we go. She say, for example, Williams asked Belknap, do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? And she got footnote 11. Oh, she got the link. She said, to begin with, this question is predicated on a falsehood. As this court detailed order on the introduction of gang lyrics proves that this is not a true threat case, and not one defendant is being prosecuted for expressive activity of any kind. Come on now. You literally are using his lyrics to prosecute him. So that was a fair question that I believe that that was asked. Young Thug Brian Steele asked the detective, do you realize that in Fulton County, he's narrowing it down, Fulton County in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics. Now the detective said, I'm not familiar with that. I'm not sure. The only one I know about is this case. And they could have moved on. So I don't know why. And that gives the jury some type of perspective that it's way uncommon for rappers to be prosecuted because they rap the song. Just because they rap the song saying I shot him or I killed him, that don't mean they actually did it. So he's trying to show the jury that just because they sing about it, just like thousands of other rappers, that don't mean that they actually did it. So I mean that's fair to show a jury to differentiate that they are being singled out and charged. And Tia makes a good point. Bonnie stated in her press conference that if they want to admit to crimes in their music, it will be used against them. And here the defense attorneys are showing that just because they're rapping about it, it don't mean that everything they say in the lyrics are true. Even though Fonnie put it out in a press conference, how ironic is that? She having press conferences and now she wants to silence the defense attorneys. But she went out in a press conference and said this. But she's saying that it starts off with a lie. The question started off with a lie. Okay. She said, plus, this line of questioning is unsourced and in conflict with known proof. How do you know that? How you know it's unsourced? How you know what the witness knows? The witness could have said, yeah, I heard of another case being prosecuted with lyrics. She says unsourced and it's in conflict with known proof. What's the other known proof? No evidence had been introduced regarding national prosecution statistics on defendants' lyrics in criminal trials. You don't need statistics. He asking a question. You don't got to poll the whole United States. He asked a simple question to the detective. He said, do you realize, not statistics realize, do you realize? She go on to say, D.A. Love said, this question also assumes that only rap lyrics have been prosecuted. Well, is there anybody else that have been prosecuted? Have y'all, do we know any other, country singers or salsa, any other genres? Punk rock, Yeah. She goes on to say, similarly, Young Thug Brian Steele asked Special Agent Rossi if he knew that Dolly, Young Thug's sister, was in a relationship with Jimmy Winfrey in 2015. The state objected because there had been no evidence that the two of them were in a relationship in 2015. And he has a footnote. Young Thug. Okay, she got the YouTube link. Let me see something. That's wild. So here, where we at? Let me see if I can find it. She goes, so this is what DA Love talking. She say no evidence had been introduced regarding national prosecution statistics. And then in her footnote, she made it seem like they had statistics. In number 30, she said, in fact, as the state's written brief on the omission of gang lyrics demonstrates, those statistics show low numbers of introduction of lyric evidence in gang prosecution. So she's saying herself that it was some type of statistic because in the state's brief, they quoted those statistics. But then up here, she's saying that there was no evidence had been introduced regarding national prosecution statistics. So yeah, this is wild. This is a wild stuff. Yeah, I'll get y'all, girl. So they're saying that also that a question was asked about Young Thug's sister being in a relationship with Jimmy Winfrey, and the state DA Love objected because there's been no evidence of the two were in a relationship. Well, that's the purpose and the point of asking a question. If I'm asking a question, it's because likely I don't know the answer. She said, well, there's no evidence that the two were in a relationship. That's why we're asking her. Most people ask questions when they don't know. Oh, you can't ask that. You got to know the answer first. You got to be some other evidence, which is insane. But Judge Glanville co-signed it. He going along with it. She says, this is DA Love. Williams, Young Thug does not have a right to float unsupported and unsupportable distractions. She say only we can do that. She say he can't float no unsupported distractions around. And guess what? And he sure can't use sworn witnesses as the vehicle to do it. He can't use Lil Woody and Tick and the other one to ask unsupported and unsupportable distractions. He can't float that around. Therefore, Williams, Young Thug's request to prohibit this court from agreeing with the prosecution and sustaining all of our objections, Glanville. She say that argument should be rejected. Footnote 17. She also says, should Williams believe that this is evidence that is admissible, he has also failed to make an offer of proof pertaining to these matters as is required by law. So a lot of times what happens is if you have a question and the judge won't allow you to ask it, you can make what's called an offer of proof. The jury can leave the room and you'll basically read your question to the court reporter, and you'll basically say, had I been able to question the witness, these are the questions I would have asked him. And you will list your questions there. So when the appeal court sees the record, they can say, okay, these questions should have been allowed, send it back for a new trial. And that's what they mean by making an offer of proof. Let's go back up. She said there is no constitutional or statutory right to ask irrelevant and unsupported questions during cross-examination. Listen to her, of course. She said the prior rulings that Glanville made, she said it's in par, it's right on with the Georgia and federal constitutions. And she said Williams' motion should therefore be denied. And she submitted that today, July 26th, about a month and a half late, Agent L. Love, the third floor, as they call it. So, we went through all four of the motions, and I'm going to check to see if anything new came out. Have y'all seen any new motions yet? Let me double check. But I do find it strange that the state has not opposed bond yet in writing. All right, yeah, I'm gonna go through. And while I go through, oh, thank you, Angel. She said, I've been sitting in the background watching and peeping the scene. So I might be new in the chat, but I've been here. Thank you, Angel, for the support. Minister Fear said it's an attitude of superiority that comes from Fulton County DAs Love, Hilton, BBL Brown that makes them seem hypocritical in all of their examination. Nunu said, I know you read 1,000 pages. She said, but I just got here. Can you summarize? Can you recap so I can know what's really going on? Well, yeah, I don't mind doing that because most of DA's Love motions are all the same. She's basically arguing against the defense. The defense want to ask certain cross-examination questions of the witnesses. Judge Glanville ruled with the state, and Brian Steele was trying to get the new judge, or is trying to get the new judge, to reverse Judge Glanville's rulings to let him ask certain questions on cross-examination. And DA's Love her motions. Two of them are like, Judge Glanville was right. We shouldn't have to. You shouldn't have to change Judge Glanville's rulings. Their questions were improper, and they shouldn't be allowed to ask them. That's the gist of that. That took care of two of Love's motions because they were similar. One was for vague questions and one for assuming facts and not evidence. The one we just did. What was her other motion? The other one was adoptive omissions. She's basically saying that statements should come in or lack of thereof. If someone says something in front of you and you don't deny it, then it could be considered an adoptive omission. So if someone is with you and they start telling people, yeah, me and Nunu broke into the grocery store, and you don't deny it, like I wasn't with you when you broke into the grocery store, you was on your own, I didn't commit burglary, and you don't deny it, then that could possibly be an adoptive omission by not denying it. So what they're trying to do is use statements against Young Thug. They're saying that, hey, stuff was said around him and he didn't deny it. But he must have agreed to it. He consented that it happened by remaining silent, which is wild in of itself. And then what's the other motion? I think the last one was from it was from the defense. The defense was upset that I don't even think he was upset. He was really just dragging her, legally dragging her. The prosecutors filed a motion to stop the defense attorneys from talking. They don't want them on YouTube anymore. They say, talk the law. What have you done? Let's say you and Kayla open up the floodgates. Because we were the original two that talked about it on YouTube. And it was brief. It wasn't like an interview because she was still under the authority of the court. But once that happened, lawyers been coming out everywhere on social media platforms talking. And the DA's office don't like that. So she wants to put a gag order on the attorneys. And Weinstein was pretty much like, hold on. Let's see if I can find it. He say, counsel does not give the state hell. Counsel just tells the truth about them and they think it's hell. Y'all hear what he's saying? Like he literally read her rights in this motion. Let me see what else he said in here that just stood out. He say, this is Weinstein, the only improper prejudice to the jury has been through the repeated eye rolling and facial expressions of 88 Love, who is sitting feet from the jurors. So Weinstein wouldn't come into play. Weinstein didn't come to play with it. He said, don't play with it, don't play with it. And I just, he pretty much saying that Bonnie Willis, is that page one? Let me see if I can find it. Bonnie Willis gave a press conference way back in 2022. That's how long this case has been going on. He said, I think if you decide to admit your crimes over beat, I'm going to use it. That's what Bonnie Willis said. She said, I'm not targeting anyone. You do not get to come to her county and commit crimes and then get to brag on it. Because when you brag on it, you're trying to intimidate and to further the gain and to not be responsible. And so what they're saying is, Bonnie Willis, you're doing press conferences. You're accusing these people of crimes, they're rapping the crimes. But when the defense attorneys come on YouTube and say a few words, all of a sudden it's a problem. So Weinstein, he wasn't here for it. She said he should have put the timestamp, right? Put the YouTube link in the motion. Let's see what else stood out. No, yeah, he should have put the links. That would have been a good icing on the cake. Wait, what's the other thing he said? Let's see if I can find it. Right. He said, free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney's Office. That's wild. Which is crazy because when the Trump trial, they were trying to keep her from testifying. They're like, Fonnie, stay in your office. Don't come out here with your mess. They were actually telling her own lawyers, they were trying to gag her. And she wouldn't listen. She came storming in the courtroom saying, oh, I'm going to testify. She want to tell it all. She want to get her story out. She want to be heard. She couldn't sit back there and take it any longer. But when the defense lawyers, not them themselves, but the lawyers say something, all of a sudden, all hell is breaking loose. So let me see. So yeah. Lady Red said the state had them cameras ready for when they arrested Thug. Then they want a gag order. Okay, for them, but not for anyone else. Right? Exactly. Somebody said Newton said she went running out of breath. She went running out of breath. She had to go tell what's her name? She had to go tell Ashley Merchant about herself. She said, you got me up if you think you gonna say I slept with a married man the first night I met him. He said, that is a lie. It might have been the second night. No, I'm just playing. I don't know when. We haven't even established a timeline when they was talking. Some people say they were already going together even before then. So who knows? Come on here, Pat Stacks, with the finesse two-time lyric. He says, cool when they do it. It's a problem when I do it. That's what he said. That's what he said. And y'all know the rest. Y'all see he got the emoji on it. Sheesh. So yeah, y'all. We got all the motions covered so far. They have about another 2 hours to submit. I'm not sure there's any motions that the defense still need to file. I mean, they did their mistrial motion, they did their bond motions, They got the important stuff out the way. So I don't know what else the defense can file at this point. Yeah, I don't know what else they can do. The state needs to file responses. Well, so what it looks like happened is Tuesday was like the deadline to get all of the motions in. And today's deadline is to respond to all of the motions that were submitted. So you get your, like each side got a chance to submit a motion and each side got a chance to respond to that motion. And anything that's not in writing could likely be heard orally, like you can argue it in person on the week of July 30th on Tuesday. So if you have anything else you want to add, like, oh man, I forgot to put that in my motion, then when you argue it on Tuesday, you can just say it. India said, I just want to see them argue the issues on Tuesday. She said, I don't want to see nothing else. I want to see them get in the ring and fight it out. And thank you, by the way, to the new subscribers. Thank y'all. Yeah, I want to see them argue it out Tuesday. She said, we're watching the fireworks. Anybody got any leftover from the 4th of July? It's time to light them up. In the meantime, while we wait, since we got a little time, anybody got a camera and a mic they want to come up and have any comments, let me know. What y'all think about the trial so far, the motions. And I'll put the link down there. Hey, if we can get that to happen, I would not stand in her way. That will be something if she take over the trial. She tell Hilton and Love, hey, y'all slide down. Y'all messing this all up. And come in there and do it herself. That would be too funny if that if she comes storming in there. I'm checking now, y'all, to see if we have anything. Oh, hey, Tiff Tate. Thank you for joining, and thank you for the cash out that came in earlier. Definitely appreciate that. Somebody says she may have no choice if Love and Hilton are witnesses. This is true. This is true. If Love and Hilton are successfully called as witnesses, she may have to put on her own lawyer hat and come down to clean up the house. Yeah, that'll be wild. I wonder what the jury think. They may really think, okay, she done lost control of this trial. If the Boston came down here, they may say, nah, that's it. This case is over. He said, I'll say bring it on, GNR. Let her try to defend her for the part and only make her fool herself. Now, that is an interesting question because there is a motion right now to remove Love and Hilton that we might find out on Tuesday as well. Will the judge send them packing? Will the judge tell Hilton and Love, pack up your laptops, pack up your outfits, and make room? Pack up your secret transcripts of the other ex parte meetings that we probably don't know about. We're trying to figure that out too. There's also been a motion to find out how many other secret meetings were held behind closed doors in a back room with the lights off. Brian still filed that motion. He said, I want to know who else have y'all talked to behind closed doors? Because if y'all done it once right in front of our faces with Woody, then I don't put it past that. I don't put it past y'all that y'all could have met secretly with someone else. She said they're coming back to a new judge. It's likely it's going to happen. I mean, do y'all think Love and Hilton should go? Well, this is actually going to turn into a normal trial. We done got the biased judge gone, so then we got a normal judge. And if we get these prosecutors out of there, it's going to really be a normal, boring trial. But in the end, it's justice is what they seek, not entertainment for us on YouTube. Even though Weinstein has been dragging them with these motions, even the other attorneys. Nia Roberts, thank you for writing. She said Weinstein's motion is lethal. She said they should have left when Glanville left, and they could have had all the secret meetings they wanted to have in the back room. She said when Glanville left, they should have kicked them all out the room. Bye. Let's see. And for the people that just popping in, we went over 4 motions total, and I believe we should be expecting a few more. So we're trying to see if they come in. Now take her to India said Hilton can stay. What y'all think about that? Hilton can stay, love can go. What y'all think about Hilton? Oh, thank you, Till. She say, drop your cat. Sharon say no. Tracy say Hilton gotta go, India. Thank you, Till. I drop it. And also thank you again to Monica B. Let me see if I can find that. Yeah, y'all kind. Monica B from Reddit. Thank you, Monica, again for that. And thank you, Tiff. Tiff's take. Let's see what they say. Especially all that sure she be killing me. She said she be killing me. They been ready for her to go. Been ready. Kim C, mistrial with prejudice. Andy said, Love and Hilton go. They just need to drop it. How are new prosecutors going to figure or get familiar with the case that quick? How the judge going to get familiar with it that quick? It's a mess all the way around. Lady Red said, no. She got to go too. She said, sure. I'm not having to play with you. Go roll. I'm not having to play with you. Will Hardy say, yeah, Hilton is a little weak. And the crazy thing is, I believe Hilton is a trial professor at a law school. She teaches trials to law students. What y'all think about that? Somebody said, no wonder all the lawyers acting a fool. Some of them in that county. Because they learning from her. Love teaching Hilton them sneaky ways. And Hilton teaching the students. And the students becoming the lawyers. Let's see. We got to keep some entertainment now. Hilton can stay. Yeah. So Andy say, yep, she is a professor. KMC say, can you go live with Caleb Bumpers? I like the positive energy you both have. We'll have to see if we can go live one day. I think we'd have been live about 3 times on different platforms each time. First here, I believe the second time, Dear World Christian, and the third time she invited me to her first live stream there. But yeah, we definitely got to do it again. Tiff State, know what you are right. Hilton State. News, she teach how to strong arm witnesses. That's what she must teach. Gotta be. Must have been. So y'all, I'm checking because they sure tried to strong on Woody, but it worked out for him in the end, at least so far. Woody been everywhere. Woody making his rounds. Yeah. Oh, she said he got a clothing line. Woody be outside. Yeah, they say they scared to come outside. Woody said he outside. Woody outside seeing if somebody Hellcat. Yeah, the only thing is, I think he made his intentions clear that he wants to stay there in his home where he's from. He has no intention on leaving the state. And, I don't put nothing past that DA's office. Because if, he get away with this, they may try to come after him. You see what they doing to what's his name? Boosie? They didn't win back and got Boosie. Ain't that crazy? And Boosie said when he went to court, the prosecutor looked at him and said, "Wipe me down." Boosie said the prosecutor looked dead in his face and said, "Wipe me down." Said Woody screaming free wild sale in that Hellcat video. I gotta watch it. From my understanding, they dismissed the charges against Boosie, and then they re-indicted him for felon in possession of a firearm. And I believe that's what Woody went to jail for the first time. That's why Woody was concerned in the back room in the secret meeting about testifying because he didn't want the feds to come back and get him for that gun charge for when he was self-defense, when he defended his family. But Hilton was like, "No, you ain't got to worry about that. The statute of limitations already passed. You good." And now Boosie, from my understanding, it was said that the detectives were on social media watching Boosie shoot a what's it called when they shoot those films? A movie. What's it called when they make a music video? Is it just a music video? The detectives was watching him shoot his video in is it California or I'm gonna have to pull it up. I kind of glanced at it last night. Let me see if I can pull it up right quick. We got a little time while we wait for some more emotions. Let me see. Boosie and All right, y'all, let me second. Well, see, the issue is, I was thinking that that could be a defense because they said that they seen him on video with what appeared to be a gun in his waistband. But by the time they made it to the scene, he was already gone. So they used a helicopter to track that man's car. And once the helicopter located his vehicle and radioed to the ground units, they pulled him over and they found 2 handguns in the vehicle. In the back of the vehicle with the security guard driving. So my question then becomes, what if they are the security guards? Because the security guard hasn't been charged. Or what if the security guard comes and say, those guns in that back are my guns? Well, what about the gun you had at the studio? That was a prop. I mean, I don't know what his defense would be, but it might be something along that. Let me see if I play this. Let's see what she's talking about. I don't know if it even let me play it. Let's see. Well, hard to say problem. Hey, what's going on, Coco? Thanks for popping in. Let's see if we can play this video.
Your company's ad could be here or on TV, phones.
All right, let me mute that. So this is the website.
Torrance Boosie Hatch has been indicted on gun charges for a 2023 arrest in San Diego, according to court records. Now, he was arrested back in June 2023 on a felon in possession of a firearm charges when officers first found 2 handguns in his car during a traffic stop. Now, those charges were dropped. A few weeks later, he was charged again with possession of a gun by a convicted felon and drug user for a separate incident. On Wednesday, Hatch posting on X that he felt blindsided by the indictment while on vacation with his family, claiming it was unfair that the indictment, quote, again on the same charge with another added.
Okay. So let's see. So he was arrested June 2023, felon in possession of a firearm. He was 5 miles away from the Phantom Lounge. Let me see, can y'all see that? Okay, where he was set to perform, they found 2 handguns in the car. All right. So I guess it was threw out because a federal court's ruling that the Second Amendment also applies to felons. Hatch felon in possession of a firearm charge was dropped by federal prosecutors in the Southern District of California. A week later, see, they're not gonna go undefeated, and that's what I'm thinking. If I get a chance to recharge this case, they don't like to just go away into the night. It's like a week later, they did they took it to the grand jury again, and they indicted him again. This time for a new charge for a separate incident that took place in May of 2023. So, golly, Boosie, what's going on? So they couldn't get him. So they got him in May 2023. Okay. So we had one in June 2023 and May 2023. According to the indictment, Hatch illegally possessed multiple guns as both a convicted felon and a drug addict or user. Not a drug addict. Boy, come on. The new indictment charges him with the latter, with the drug addict. What? He was filming a music video at the time of his arrest. He has a long history of drug and gun offenses. On Wednesday, Hatch posted on Twitter he felt blindsided by the indictment while on vacation with his family, claiming it was unfair on the same charge. I'm on vacation with my family. My lawyer called me and said this federal prosecutor has indicted me again on the same charge and added a charge that I was a drug attack around a firearm. Shaking my head, why did you charge me with that the first time? Oh, wow. I don't know if I can make that. I don't know if that'll open. The first time. The judge has ruled at this point you're making this a circus. This has to be unconstitutional. This shows how far these devils will go to try to stop a successful black man with a voice. This man has a serious vendetta of hate against me. He wants to be a character in a movie. He just doesn't respect the courts. He races and has no respect for the courts. If I wasn't Boosie, this would not be happening to me. This same man looked at me, said, wipe me down on my first court appearance, laugh out loud. He's obsessed. I never seen nothing like this in my damn life. 30 of us on vacation and I get the news. He put his hardest battles on his strongest soldiers. God's got me. This man doesn't respect the law. Tell the president to pardon his BS. Justice for Boosie. David Ross said, well, pray for you, bro. I really believe they are trying to silence Christians with a voice. Stay strong and never back down from the Lord. What y'all think about that? What do y'all think about that? This is insanity that they can go back and harass him like that. Let me see what else they said. Well, that is. Do y'all know if any other motions came out so far? I've been checking. I haven't seen nothing pop up in the queue. Oh, you had asked me this earlier. Can you pull up a state lawmaker from Atlanta suing DA Fonnie Willis? What is her complaint? What is she suing her for? I mean, we got a little time while we waiting. What she? Let me see. Oh, okay. Let me see it. We got a clip real quick we can play.
County District Attorney Fonnie Willis now being sued by a state lawmaker. Republican Representative Misha Maynor says Willis, among others didn't do enough to prosecute Mainor's stalker and even work to help him get less jail time. Atlanta News First political reporter Doug Reardon is live outside of the Capitol for us tonight, live at 5. And Doug, Mainor's case has been going on for more than 6 years. Why file a lawsuit right now?
Right, Tori. We asked her that exact question when she gave us a couple minutes here at the Capitol today, and she said she tried to do everything that she could behind the scenes to handle these problems, and even got some stalking legislation passed here this session, but got no help from the DA, so she filed a lawsuit seeking some accountability. Mainor was stalked in 2019 by a former staffer who was working on her state house campaign at the time. She was granted a restraining order after his behavior became, quote, unruly and belligerent, according to the lawsuit. But Mainor is accusing District Attorney Fonnie Willis and Fulton County Commissioner Marvin Arrington, who is also her stalker's defense attorney, of working together to craft a plea deal and downgrade her stalker's charges from a felony to a misdemeanor without telling Mainor. He ended up serving no additional jail time, and Mainor said filing a lawsuit became her only option.
It's been over 6 years, and I have been silent about it. I've gone behind the scenes trying to seek justice for myself. This is the last straw.
And we did get a response from the district attorney's office on this today. They said, quote, Representative Mainor's allegations are baseless. We have not been served with the lawsuit. If we are confident it will be dismissed. No comment, however, tonight on this from Commissioner Marvin Arrington's office. Representative Mainor is requesting a jury trial to see if either of them strayed from doing their duties as officials of Fulton County. We're outside the state capitol. Doug Reardon, Atlanta News First.
Well, there we have it. There we have it, y'all. This is insane. Now, I don't know how far that lawsuit will go. Probably not that far at all. But maybe it's just the principle. Maybe. All right, y'all. So we were trying to wait and see if any more motions would come out today, but it don't look like it. I mean, because if they were going to come out, they would have came out by now. You missed it all. You missed it all. We went over like 4 motions, and we were trying to wait to see if any more come out, but I don't think so. I mean, so it looks like we'll be back on Tuesday. And on Tuesday, they would argue the motions unless something changed. And before I go, I give y'all one more chance. If y'all have anything y'all want to say, come up, say anything. I got a camera, might let me know. Click the link. Right. She said the final hour is always the best hour. Yeah, I don't mind popping back on if something come up. Now, if it's like a repetitive motion, they saying the same stuff they done said 100 times, and, we'll just catch that on the back end. We'll catch that one on Tuesday when they argued it. Come on here, Nunu. That's a good point. If the state doesn't respond, it's silence and admission of agreement. Come on. Y'all see what she did there, huh? She's saying it's an adoptive admission. She said, pull up this timestamp. Yeah, I don't know what timestamp to what. She said, pull up this timestamp. Y'all know what she mean? We'll just get it on the next round. I bet as soon as I get off of here, we're gonna get word that there's a we're gonna get word that there's a new motion out and about floating around. All right. Let's see. So we got all right, y'all. So I said, what's your overall thoughts? Yeah. I don't think they responded to the right stuff. I think they should have at least responded to like the motion for the mistrial, the bond, some good motions. I mean, I think they wasting time talking about Glanville stuff. I think that's a waste of time because if the prosecution, DA Love and DA Hilton, if they have a problem with any questioning going forward by Brian Steele, they can always object, and then the new judge, the current judge, can make a ruling. You don't have to put on paper, hey, Judge Glanville was right when he did it back then, so new judge, you should do it too. No. This new judge already said she got her own mind, her own way of thinking, and she gonna rule on the motions as it go. Oh yeah, my email's in the description, Keys. But whatever you get, send it to me, and then when we get back on, we can just catch it on the next round. Yeah. All right, y'all. Thank y'all for joining in. If anything come up, let me know, and then I'll pop back on and we can cover any significant motions. But I don't think we're gonna get nothing that's gonna be just jumping like that. But before I go, let me give my legal disclaimer. I'm gonna say I done talked about love, I done talked about Fonnie. I gotta give some type of disclaimer. He said they pled guilty as charged. Boy, you say everybody guilty every time you come on. I already knew he was coming. He say, Fonnie, Miss Love, Miss Hilton, thank you for cleaning up the street of Georgia. Miss Hilton is doing a good job putting YSL guilty of all crimes. Guilty. He's funny. He do this every time. He ain't gonna do that. He ain't gonna do that for sure. Oh yeah, thank you, Keys. Mo. Yeah. All right, as I was saying, my legal disclaimer, no legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk that law. All right, thank y'all for joining me, and hopefully I can see y'all on Tuesday. And if we get something before then, I'll be back. So y'all have a good weekend, and I'll see y'all on the next one. Let's go.